All right, well, welcome once again, and thank you very much, everyone, for joining us. It is that time of the week, you know that time, the time when I log in here to talk to you about employment law and workplace rights, the time that I dedicate to just answering your questions. So if you haven't been here before, if you don't know what this session is all about, first of all, welcome. My name is Lior Samfiru. I'm an employment lawyer, and I'm the head of the employment law practice at Samfiru Tumarkin LLP. Again, my name is Lior Samfiru, and as an employment lawyer, what I like to do every Wednesday at this time, I like to log on to YouTube, to Facebook, and to answer your questions. This is an opportunity for you to learn about your workplace rights, to find out what you need to know to solve your problem. So I'm not just here talking, even though I have a lot of things to talk about, like I always do. What I really want to do today, as every week, is to answer your questions. So if you have questions, workplace problems, if you've always wondered about something, maybe you're in a situation where you've been given an ultimatum by your employer. You have to do this by Monday or else. What can you do about it? Should you do something about it? Whatever the question, whatever the issue, I promise you, there are answers, there are solutions. We may have all been in lockdown over the past number of weeks and months, but guess who's not in lockdown? Employment laws. They're not in lockdown. They're still there. They still are doing their thing. And hopefully in this session, like I do every week, I'll help you understand what your rights are. So you see a box on your screen, type your question, press enter, and you'll be able to ask me whatever it is you need to. I'll read it, I'll answer it, and you can walk away hopefully having those issues resolved. Now, I'll give you another contact information because we're here for the next 30 minutes, but you may want to connect with me off air. You may want to have a private discussion about your matter. I love that. I encourage it. So please do that. You can reach out to me through employmentlawyer.ca. Again, that address, employmentlawyer.ca, the address you can go to get my contact information, phone numbers, email address. You see that on the screen right here. You can also learn a lot about employment law at employmentlawyer.ca. Your first and your best resource if you have any workplace issue. Certainly, if you lost your job. So many people now over the last year with COVID-19 have lost their job. Well, guess what? Your rights not only still exist, your rights are actually enhanced during COVID-19. You may have more rights, additional rights than you would otherwise because COVID-19 has intervened and has made things more difficult for you now to find new work. So don't assume you don't have rights. You have a lot of rights. So right now, ask your question. I'm going to start answering them right now. In between your questions, I have other topics I want to discuss, but this is not about me. This is about you. This is your session, your time. Ask your question. Take advantage. First question of the day, welcome, comes to us on Facebook from Lyle. Just wondering if your firm operates on a contingency basis. We get that asked often. Yes, almost all files that we take, over 80%, are on a contingency. Most of the people that hire us are people that are in difficult financial situations. They may have just lost their job, or maybe their pay has been impacted. So yes, for us to say we're going to charge you a lot of money on an hourly basis may not make sense. So yes, most of our files are on a contingency basis. Most of our files, we do not charge anything unless we're absolutely 100% successful. So if you want to have a chat about your matter, reach out. Let's have that discussion. Thank you very much for that, Lyle. If you have any other issue or question you want to ask now specific, please take advantage. Patricia, next question. Thank you very much, Patricia, on Facebook. She says, in regard to sick leave, what documentation, if any, does an employee need to provide to an employer in order to have a record of employment issued for illness or injury? Employee wants to take 3.5 months sick leave prior to her maternity leave. You need a doctor's note. That's all you need. You need a doctor saying, for medical reasons, you cannot work. Now, you don't even necessarily, the note doesn't even need to say what the medical condition is. Doesn't matter if it's related to the pregnancy or it's not related to the pregnancy, if it's a physical or a mental health issue, you need a doctor's note. Once you have that doctor's note, you can be off as long as you need to. Your employer is going to have to issue a record of employment. You will qualify for government benefits. If your employer gives you a hard time in any way, shape, or form, call me. But you need a doctor's note. Very simple. Any problems, you know what to do. employmentlawyer.ca. I'll get involved and I'll help you. So thank you for that, Patricia. just like Patricia, just like Kalil, ask your questions. I'm going to continue answering. Questions are coming in. I love it. So let's get at them. Isabel on Facebook. If you are on LTD, that's long-term disability, but will be 65 in a few months, your intention was to work beyond 65 if your health was better. After 65, are you allowed to reach out to your employer and request return to work? Absolutely, yes. You may be cut off your disability benefits at 65 because the policy only goes to 65, but you can return to work, absolutely. So yes, you haven't lost your job. You don't lose your job just because you turned 65. That would be illegal. And when you're ready to come back to work, your employer has to make all efforts to take you back. If they don't try, if they don't want to, that's illegal. That's a wrongful dismissal. That's potentially a human rights violation. Can't do that. Now, if they absolutely try and there's nothing available, at that point, they can let you go with full severance. But that's only if they've tried, they've looked, they've made all the efforts to find a position for you. Then and only then can they consider termination. So absolutely, Patricia, Isabel, I should say, you absolutely can be off past 65. You're allowed to return to work, and your disability benefits have nothing to do with that. So don't worry about it. Any problems, you know what to do. You reach out to me, employmentlawyer.ca, to do that. Next questions, guys. I love questions coming in. Bring them on. Keep going with them. Next question comes to us from Sandeep. An employer has not been paying despite having a compliance order from the Ministry of Labor. So that's when you need to get us involved. The Ministry of Labor is good at issuing orders. They're not particularly good at enforcing those orders. Let's have a chat. Let's connect off air and let's figure out what can be done about it. The key here is the employer still operating? Does the employer have the money to pay? You know the saying, you can't get blood from a stone. So if the company legitimately has nothing, zero, no money, no assets, nothing at all, well, you're not going to get paid. But if there is money, there's assets, there's money coming in, there's property, yeah, we'll be able to enforce that. So let's have a chat about that. You want to connect with me again, Sandeep, at employmentlawyer.ca. Again, employmentlawyer.ca. So if you have follow-up questions, guys, today, and you don't get to them today, or I don't get to them today, well, let's do that privately, right? Let's have that chat privately on the phone, by email, or on a Zoom call, whatever it is. You can reach out to me, have all my contact information at employmentlawyer.ca. See also the email address right there. There you go. And you can contact me that way as well. But right now, don't worry about that. Let's talk right now. Ask your questions. We have plenty of time. Next question today from Evelyn. So Evelyn says, I was on sick leave since April 2020 and still on CRB. Last 4 days, 4 days ago, I got a message from my employer that I'm ready to go back, or I messaged my employer that I'm ready to go back to work, but until now, I did not get any answer. If they don't answer, can I consider this a layoff? Do I have the right to ask for record of employment and file for EI? So here's what you do. You do follow up with them, okay, and say, please get back to me as soon as possible. Give them another 3 days to do that once you follow up. If they have not responded, number one, wrongful dismissal. Number two, potentially human rights violation, all right? So you're entitled to, yes, EI, record of employment. You're entitled to severance. Depending on how long you've been there, Evelyn, you could be owed 24 months pay. But the reality is, to get all those things, you're going to have to give us a call. If you simply tell your employer, give me my severance and my record of employment, they won't do anything. They'll ignore you. We have to get involved. So follow up with them. Give them 3 more days to respond. If there's no response, call me. Okay, don't wait, or email me, employmentlawyer.ca, Evelyn, to get that contact information, and I'll help you get what you're owed. If you have a follow-up question right now, take advantage. I'm here, but that's what I want you to do. Okay, Evelyn? Hopefully that makes sense. Okay. Next question again on Facebook from Ivy. Are these needles, I guess you mean the vaccines, are these needles mandatory? Employers are saying you have to have it. So no, Ivy, they're not mandatory. And in most cases, your employer can't require you to do it. Now, only in very rare situations where you're in a job that has to be you're dealing with vulnerable individuals, you're dealing with sick people in a hospital or long-term care, maybe in those situations. For most other places, they can't do that. That could be a human rights violation. Again, if your employer is still insisting, let me get them off your back. Usually a letter from me is all that's going to be required. But for all of us here today watching, in most cases, in the vast majority of cases, your employer is not allowed to mandate that you get a vaccine. They cannot say, if you don't get vaccinated, you're not working. They cannot say, if you don't get vaccinated, we're letting you go. If they do that, you call me. That's illegal. You may hear about all kinds of stories, employers doing that. And a lot of employers may believe that they're allowed to do that. They're not, okay? So reach out to me if that's happening to you, employmentlawyer.ca to do that. So from Bill on YouTube, is retaliatory dismissal illegal in Canada? So depends on what we mean by retaliatory. If you're let go because you're pursuing your legal rights, so let's say you're asking for overtime or you're asking for vacation pay and your employer says, well, I'm upset that you did that, so I'm letting you go. We call that reprisal, which is a form of retaliation. That's illegal. But if your boss lets you go because you asked for a raise, that's not retaliatory. They can still let you go, but they have to pay you severance. So you cannot be punished because you asked for something. And in some cases, it's actually illegal to let you go and you could get reinstated. Whatever the reason you were let go, whether it's a good reason or a bad reason, you could be owed up to 24 months pay, all right? You want to give me a call right away to discuss it. Thank you for that. Then next question, ask your question, guys. We have time. From Raymond on YouTube, what is wrongful dismissal? So wrongful dismissal is a situation when you've been let go and have not been paid the severance that you're owed, have not been paid what you're owed on termination. So if you're let go, your entitlements are based on a few factors: your age, your position, and the length of your employment. The longer you work, the older you are, and the more senior a position, the more severance is owed to you. All right, then. So let's say you're owed 12 months. If your employer pays you less than that or offers you less than that, that's a wrongful dismissal, okay? So most people, believe it or not, when they're let go, they're actually wrongfully dismissed. In 90% of cases, when someone is let go, they're owed a lot more severance than what they've been offered, okay? A lot more. So chances are, if you've been let go, you've been wrongfully dismissed, and you got to give me a call. And by the way, to find out if you have been wrongfully dismissed, to find out what you're owed, right now, go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. We have our severance calculator tool there that allows you to find out in seconds how much severance you're actually owed. Raymond, you say you were there for 7 years. You could probably owed 8 to 9 months pay. If you've been receiving less than that, call me. And you can see on the screen right there, pocketemploymentlawyer.ca. Thank you very much, Raymond, for that question. Feel free to ask a follow-up. From Barbara, if an employee recognizes they are not working out in the role they had for 3 years and asks for a transfer, how do we end that first role and provide severance for that role if a new lesser role transfer is put in place by us? So if an employee is asking for a transfer, you don't have to pay severance. You don't have to terminate. You can simply say to the employee, well, here's the job that we have available. Do you want it? If they want it, they can take it. If they don't want it, they can stay in the role that they had. You do not have to pay severance as the employer if you're transferring, if the employee is asking for it. If you're the one that's demoting someone, you're doing that unilaterally, that employee may be able to treat that demotion as a constructive dismissal and make you pay them severance. But if the employee is asking you for a transfer and you're simply giving them what they've asked for, you do not have to pay them any severance. You do not have to terminate employment. They simply continue working in that new role. All right. So hopefully, Barbara, that helps you understand that. Ask any follow-up questions, guys. We're getting lots of questions today. Please, this is amazing. This is wonderful. Ask your question as well. I'm here for plenty more time. Next question today from YouTube, from Sitting Pretty 64. I was on short-term disability and was terminated. 6 months later, I received a reversal stating I was approved. Do I have any rights left? I'm in the process of waiting to go to court. So I'm not sure if you're saying you were terminated by your employer or by the disability insurer. Okay, so you want to clarify that to me, because my answer is going to be different depending on whether or not you were terminated by your insurance company or by your employer. If it's your employer, I'm not sure exactly what you mean by a reversal. So you may want to give me some more information here, Sitting Pretty 64, and I'll be able to answer your questions. So next question. Okay, I was terminated. Oh, okay, so Sitting Pretty says I was terminated for not returning to work. Well, if you're unable to work, then, and you have a doctor's note, your employer can't terminate you. So I'm not sure exactly what you mean by a reversal. Did they change their mind? They can't change their mind. They have to pay you severance. Now, in terms of going to court, you don't need to go to court. These matters can resolve. If a lawyer is telling you have to go to court, that means that lawyer doesn't know what he or she is doing to resolve the matter. Okay, we can resolve matters like that quickly. It's not a problem. Okay, you want to reach out to me, happy to have a chat with you about it. And again, for you and for anyone else, anyone just joining us, to contact me off air, off Facebook, off YouTube, off social media, to have a private discussion. Easy. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that at the bottom of your screen. You'll see all my contact information, my whole team's bios and contact information, phone numbers, email address, fax numbers, address, physical address. It's all there. You can do that, and by all means, feel free to use that information. But right now, let's do differently. Let's do it differently. Right now, let's ask your questions, post them, I'll answer them, and you can take that information with you. Question from Ashley. I work for an airline, but I'm worried about getting the vaccine. Can the travel industry be mandated to get vaccines? So first of all, if you are in the travel industry, you're probably part of a union. So you have to talk to your union. The only one that can mandate a vaccine is the government. So could they say that anyone in the travel industry has to get a vaccine? Yes, they could. The government is allowed to do that. They have not done that, and they have not given any indication that they will do that. But they can at some point, and if they do, there's not much that we can do about that. We have to comply. Your employer, though, can't require you to get a vaccine, although if you are part of the union, you have to discuss this with your union, okay? Hopefully that explains it, Ashley. And by all means, please ask away right now. I should mention, of course, that pretty much everything we talk about here on these sessions applies only to non-union employees. It does not apply to unionized employees. It applies to non-union employees. Unionized employees have different rights that are in the collective agreement, and only the union is allowed to really help you or to enforce your rights. So everything we talk about really generally applies to non-union employees. But next question from Bill on YouTube. A little more info. I was fired because I had brought forward harassment and toxic work environment allegations at my former work site. So that is a classic reprisal. In other words, Bill, you cannot be let go for complaining about harassment or complaining about a toxic work environment. No, that's illegal. That's a breach potentially of at least 2 statutes. So no, you cannot be let go in those situations. So of course you're going to be owed severance, potentially additional damages. You may even have a right to reinstatement, potentially. So there's a lot to discuss here, Bill. I obviously would want to know more about your job, about the harassment, about how you complained, about when you were let go after you've complained, what you've been offered, if you've been offered something. So Bill, we have some things to discuss. I want you to reach out to me through employmentlawyer.ca so that we can have that discussion. All right, don't just sit on that. Let's make sure that we have that discussion, and sooner rather than later. All right, employmentlawyer.ca. Okay, I'm going to continue asking questions. You guys ask them, I'll answer them. I'm not going to stop. Next question comes to us on Facebook from Patricia. A long-term employee accepted a different, higher-paying position. Within a couple of months, it was clear this employee was not able to do the job. What options or responsibility does the employer and the employees have? So in terms of the employee, all the employee can do is do the best job that they can. If there's a reason they can't do the job, maybe they're not given proper training, or maybe there's a medical reason, they have to tell their employer that. In terms of the employer, they have to performance manage. So if the employee cannot do the job, they have to discuss that with the employee, maybe put them in a performance improvement plan. And ultimately, clearly, if the employee can't do it, despite the help, despite the training, maybe you can terminate for cause, maybe you can transfer to another position, but or even better, have that chat with the employee. Maybe you and the employee can agree right away that maybe a different role is more appropriate. But remember that if you just decide, well, we're going to let you go, but you haven't done the work to try to fix the issue as the employer, you're going to have to pay severance, even if the employee has worked for a short period of time. So short period does not mean no severance. In fact, the opposite is true. Well, in fact, I think you say that this person is a long-term employee. So don't just let them go. Performance manage, talk about other options that are available. The employee, again, if you have a reason why you can't do the job, let them know. If you feel you haven't been trained, or if you feel that there's not enough support, or maybe there's something else that's preventing you from doing the job, let your employer know so that they know it's not just you not trying, that it's not just you avoiding doing a good job, okay? Hopefully that helps. Patricia, feel free to ask any follow-up questions. Now, I mentioned this tool earlier, but I'm going to mention it again. PocketEmploymentLawyer.ca. PocketEmploymentLawyer.ca. So what is that tool? Well, that tool is like having your own employment lawyer with you, whether you're on your smartphone, whether you're on your desktop, your laptop, your iPad, doesn't matter. You go to PocketEmploymentLawyer.ca. You see the address right here. And we have a bunch of tools there that allow you to find out your rights. Maybe you lost your job and you want to know how much you're owed. We have a severance calculator tool. Maybe you believe you've been constructively dismissed and you want to find out if that is a constructive dismissal. We have a constructive dismissal tool. Allows you to find out if your situation is a constructive dismissal. Maybe you want to find out if the company, really had just cause to let you go. It's very difficult to terminate for cause. Well, we have a just cause tool. Allows you to find out if it's cause. You may want to find out if you're an employee or an independent contractor. Many people are misclassified. You're not sure which one you are. Well, we have our tool there. You want to find out if your matter is a human rights violation, if it's harassment. We have tools for all that. They're all free to use. They're all anonymous. You don't have to put in your name. It doesn't cost anything. You don't have to put in a credit card information, nothing. It's just there for your information. The very first place to go to if you have a legal issue, an employment law issue, PocketEmploymentLawyer.ca. And there's also a button there that you can use if you want to contact me directly from PocketEmploymentLawyer.ca. All right, so hopefully that helps. Check it out if you go there. Patricia says, apropos this, Pocket Employment Lawyer is great. I provided the links to my BC CPHR Association. Awesome. I'm glad to hear that. Use that as well. Please use it. Technology is wonderful, and we're taking advantage of technology to allow us to give you assessment of your situation, to give you legal help and legal information. So PocketEmploymentLawyer.ca. All right. Continuing with questions. All right. Next question comes to us from Ryan. I was in contact with someone who had COVID. My employer says I should return after 5 days or take a layoff. How long can I quarantine before it impacts my job? So you can quarantine as long as you need to based on health authorities. Usually they tell you to quarantine for 2 weeks, but whatever public health says to you, that's what you can do. You cannot be let go for those 2 weeks. Full stop. You have what we call a job protected leave. Okay, it doesn't matter what province you're in. You cannot be let go because you have to quarantine. So if public health says you have to be quarantined for 2 weeks, you quarantine for 2 weeks, not a day less. Okay, follow what public health says to the T. Your employer cannot do anything to you. If they try to do anything, lay you off, threaten you, reduce your pay, reduce your hours, call me. I'll set them straight. It's not going to be difficult. Sometimes an email or a letter from me, it's all that's going to take, okay? You can be off as long as you need to if you're following public health guidelines, and you cannot be let go because of that, okay? Let's be very clear. So thank you, Ryan, for that question. Next question from Yolanta on Facebook. Can the employer make you sign a letter that states the employee will not travel during the pandemic? No, they cannot, but they can certainly tell you that if you do travel, you're going to tell them. All right. But here's the thing. If you're going to travel and there's going to be quarantine obligations, that means that you cannot come back to work because you chose to travel, that's going to be a problem. All right. So depending on where you live, if you, let's say you travel somewhere and you come back, then you may have to be unable to work for a couple of weeks because you have to quarantine. Your employer may have a problem with that, saying it's one thing to approve your trip, to approve your vacation, but I didn't approve an extra 2 weeks. But if you don't have to quarantine, if you can travel and come back, go back to work right away, then you have no problem. So your employer can't tell you not to travel, but if you do travel and because of that now you can't work for a while, that is a problem. Okay, potentially that could be something that's considered a resignation, a job abandonment, maybe even cause. So I'd be very careful in that situation unless the employer approves it. Now, of course, if your job is remote anyway, it doesn't matter because even if you quarantine, you can do your job. So, but if your job is physically you have to go somewhere and you won't be able to do that because you chose to travel and now you quarantine, that's going to be a problem, unfortunately, Yolanta. All right, so hopefully that helps. So guys, if you have any more questions, I'm here for another couple minutes or so to answer them. So please take advantage. You know, I want to answer as many questions as possible, but just because I'm going to turn off this camera in a couple of minutes doesn't mean I'm going anywhere. In fact, I'm not. I'm going to take the jacket off, but I'm going to get back to work answering even more questions. And you can always contact me on online or by phone. Just go to employmentlawyer.ca. You'll see my email address. You can email me directly, ask questions. So please take advantage of that, even when we're off here. But we're not off yet. I'm still here. You're still here. So ask questions, and I'm going to continue answering them. So from Raymond on YouTube, if I'm working with a contractor and they fired the contractor and they never fire me, then dismiss me. So I'm not sure what the question is, but if you lost your job, Raymond, you're owed severance, okay? Now, depending on the arrangement, if you work for a contractor who works with someone else, maybe it's the company that has to pay you, maybe it's the contractor, but someone's going to have to pay you severance if you lost your job. Obviously, I need more particulars about the type of job, how often you worked, what you were earning, but yes, you're owed severance if you lost your job. And that's a very important message for anyone. People ask me, when do I get severance? Well, the answer to that is if you lost your job. Whatever the circumstance, if you lost your job, you're going to be owed severance. And in some situation, you could be owed severance even if you haven't lost your job. If it's a constructive dismissal, if your pay was reduced, if you've been laid off temporarily. By the way, temporary layoff, it's a constructive dismissal. You're owed severance, even now during COVID. If your hours have changed, if your shifts have changed, or your work location, you can treat that. You can choose to treat that as a termination and get severance. Okay, so if that happens to you, I want you to contact me so that we can talk about all those options. Next question from Ida. I'm a dental hygienist. Morally, it was withheld from my employer and employees that one of the employees' husband was testing positive while the wife was at work. He tested positive. She went to get tested as well the next day. My employer withheld it as he didn't want me not going to work. Yeah, no, that's certainly illegal. And by the way, the fact that your employer puts you at risk like that, number one, you can file a complaint with the Ministry of Labor. Number two, putting you at risk like that could be a constructive dismissal. If you work for an employer that has no regard for your safety and puts you at risk like that when there's a pandemic going on, you may be able to say, well, I don't have to continue working in that situation. Okay, you put me at risk. I'm going to treat that as a constructive dismissal and get severance. Depending on how long you've worked there, you could be owed as much as 24 months pay. If you want to get that severance, please let's have a chat and let's talk about that. So those are your options here. So Raymond says, I was there for 7 years and was working for $355 per day. Yeah, you could easily be owed 8 and 9 months of severance. Okay, so Raymond, you need to contact me off air, off YouTube, off Facebook, so we can have that discussion. So that's where we are right now, guys. I think I'm caught up on these questions. So we're going to end this here. I'm going to be back next week, but I don't want you to wait another week. Please don't stew. Don't let these questions fester and drive you crazy. You can contact me once we're done here. Send me an email. Give me a call. employmentlawyer.ca. You'll see that on the screen to reach out to me. You can get that information there. I'll be back next week, but don't wait until then. This is always a pleasure to be here. It's always a privilege. I know these issues are important. I take them very seriously. So thank you very much for participating today, everyone. We will see you next time. I'll get back to work. employmentlawyer.ca to reach out to me. You also see the phone number right here, right there. So please reach out to me anytime, okay? Thank you, everyone. Have a great rest of your day and great rest of the week, and we'll talk to you soon. Bye-bye.